Welcome to Module 5. I have two students that arrived on time. I hope somebody else comes. One of the first things that we talked about a little bit, just as we were sort of preparing, is malpractice versus ethical violations. I could phrase that to say two things. In what ways are they totally separate? In what ways do they flow together as one course of conduct? Heather and Zaria, you can put in the chat or unmute and talk, but what do you think lack of diligence is? Ethical violation, malpractice, or could it be both in some cases? Lack of diligence. In other words, there's 5 things to do, and the lawyer and staff really only do 3 out of the 5, and they sort of shuffle, procrastinate on the other 2, so they're not really ready. Let's say there's a contested case, or there's some difficult documents that need to be drafted on time to make everything work for the client, and they really don't do a lot of thorough work on time. And Heather and Zaria both think it could be both. Yes, it could be. Technically, malpractice lawsuits will be dismissed if there's no client damages. If the client does not actually lose something that's compensable in money, there's no malpractice case. So, yeah, that's the biggest difference. I agree. The question being, is that the basic difference? It's not the only difference, but it's a basic one as far as practically an instant analysis. You say, oh, this is terrible. This is terrible. What has happened? This person came in and said their former lawyer goofed up terribly by not doing anything. Okay. Well, then it turns out that there's still time to fix. So let's say your law office fixes the fact, and it doesn't really cost any more than if your side, your law firm had handled it from the beginning. So the client really has not lost money, but a lack of diligence still occurred. The lawyer was still unethical, even though technically there's no negligence case. When we say malpractice, it's basically the same as attorney negligence. There was some carelessness in what was done, or more typically, failure to do anything is the biggest problem. That's why I harp so much with paralegal students about do something, get something on my desk. Just as in a good law office, the lawyer insists that you produce something on time. If the lawyer has to get it done on Monday, the lawyer probably wants you to get your part done on Thursday. Does that make sense? Yeah, Heather says yes. Okay. So yes, and it makes sense because the lawyer is responsible legally not only to the client, but to the malpractice carrier, to the system of justice, to be prepared on time. Let's say that the yeah, and commercially they need to have legitimately billable time, not fudge and say, well, I did that work on Friday, I did 4 hours of preparation, when actually they just grabbed a sheaf of papers and just winged it on Monday at a court hearing. That would be terrible, but it's not excusable for lawyers who have some control over their own schedule and time. They're able to take cases or refuse cases. I do have a lot of sympathy for lawyers who work for certain agencies, prosecutors, defense attorneys who are public defenders who are just handed dozens of cases, and you can either process those cases and work on them, or you can quit your job. There isn't a third choice for those folks sometimes. Does that make sense, folks? Okay. Yeah, I mean, and one of the things though that advantage we had in the old days, the very old days when I first started, then we lost that advantage. Then to some extent it came back, but one of the advantages beginners had um, was that when the employer just handed you a bunch of papers and a bunch of files and sent you up to court, and this is as an attorney, not a paralegal, but it relates to paralegal work. I remember they just gave me a bunch of files. It was called the sink or swim method. Um, you know what sink or swim is? It's where they just throw a kid in the pool and say, well, they'll learn to swim. Yeah, well, they threw me in the deep end. They just handed me a bunch of files, some of them felony files, and and I said, well, what are these about? What am I supposed to do? And they said, well, um, there's a there's these hearings, omnibus hearing. I said I didn't know what an omnibus hearing was. I knew the technicalities behind the omnibus hearing, but in law school they don't teach you the state specific stuff as much as you think they do. Yeah, but sending me up to negotiate and to make appearances in cases where I knew nothing about the case, they handed it to me just before court, like 10 minutes before court. That was not smart. When I finally hired a lawyer years later, we didn't do that at all. I went over every detail of every case with the new lawyer that worked for me, or fairly new. He had worked for another law firm, but on other things. I went over every detail. When he went to trial, I went with him until he had totally been schooled on how to do trials. Does that make sense? Or what do you think about that? What do you think about that? I don't believe in sink or swim, even with swimming. Yeah, I just, but in the olden days, the very olden days, when I first started, I went up there and I basically, normally it's the client who throws themselves on the mercy of the court, but I threw myself on the mercy of the judge. And but luckily, if you go there on time or a bit early, 5, 10 minutes early, the judge would meet with the lawyers in the chambers and they'd talk about the procedures. And the judges actually mentored us a little bit. Um, and I remember that. And the defense attorneys at that time, and I later became a defense attorney as part of my work, but that time I was a prosecutor. Well, the defense attorneys were making these strange arguments about the law, and I didn't know how that really related to what we were really supposed to do that day in these preliminary hearings and so on. And they were trying to get evidence thrown out and all of this. I basically pleaded for extra time because I said, well, Judge, you know I'm brand new. I'm just introduced myself. Um, and I think the judge knew that they were just testing me. And the judge explained of what was going on with the types of hearings. And of course, I knew the substantive law, but I didn't know the procedures of the hearings. Because I didn't realize I was going to get that kind of a thing right away. I thought I was going to do child support collections and misdemeanors, which have a different procedure. But anyway, it all kind of worked itself out. But later on, lawyers were thrown into the deep end and the judges didn't help. And like I say, up till recently I visited lawyers and went to court with them, and the judges were back to being a little easier to get along with. So, but um, the had the judges not been a little bit kind, I suppose I would have been guilty of malpractice, even though I really had no uh, choice really in the matter in a certain sense. But then my employers would have also been guilty of malpractice, I suppose. But being as we worked for the state, I suppose nobody would have sued us. I don't know. But certainly it wasn't an ethical way to operate, I suppose, because but I think although maybe it wasn't that bad because my employers knew that the judges would cut me some slack if I asked for it, I guess. But I did not do business with that later on. I hired an attorney named Paul, and we went over every detail of how to do things before he went to court. Um, I don't even know that, Heather. I don't know if I think in our case the county didn't have um, malpractice because I don't think the county ever sues its own attorneys for county attorney work. Um, but I think that if you get sued by somebody else, the county would have helped us. Um, so we're going to talk about non-lawyers who can do malpractice and consequences from unethical conduct by a paralegal and what's competent and professional. One of the things that would have helped, of course, in that situation um, would have been if we'd had paralegals involved and a experienced paralegal could have gone with me and said, well, basically what an omnibus hearing what is in our state is a combination of these two hearings. Um, and then I would have understood it, okay? Because I knew the constitutional basis for the hearing and I knew the basics, but I didn't understand the jargon that they were using in my state at that time. And the paralegal could have explained that to me. And then, of course, in that case, the judge actually explained this. So then it gets easier. Try to write down, you've already come up with some good questions, but try to come up with, those of you that are watching by recording, try to come up with some questions that help you focus. It doesn't necessarily mean that you have to ask me the question. If you think that you already have a clue to the answer and what you find out from readings and from what I say answers that you don't have to ask it, but consider putting it into a course message or text to me. If you're searching for answers as you listen, um, you will remember so much more. Have I talked to you, Heather or Zaria, about the messy room lost keys story? Okay. I do that every term, but some people that have had more than one course from me, and then sometimes I will repeat myself. I'm getting to that age, but um, my challenge to students and challenge to myself is go to a friend's house sometime and don't have them hide their keys, but have them hide something that would be fun to find. And if you're looking for something in their living room, you will learn 20 things about them and their living room. You'll find out which side of the family has more pictures up. You'll find out um, whether their couch cushions are the same color on both sides. You're going to find out 20 things, I think, that you'll remember pretty well. If you went into the same room and just tried to memorize things about the room in the same 5 minutes or so, you would probably only remember 7 things. If you were just trying to look at things and not really look for something. Um, I think most of us can imagine how that would work, but it pays to actually try it. If when I went to my son's house and he had lost something, and I'm going through when he went to my house and I had lost something, we learned all kinds of things about each other's houses. You memorize, you know things that have nothing to do with the actual lost keys or lost cell phone or lost wallet or whatever. You learn those things. So try to think about a question and that becomes your lost keys. You will learn more. Accelerate what you do so you don't miss the deadline. The deadline for everything is Tuesday, May 11th, 1 week from tomorrow. Nothing submitted later earns points. Heather has a question. If you file an ethical violation, you do not get action. Who do you escalate to next? Good question. Against an attorney, you mean? Okay. Well, if it's turned down by the original investigators, you could write to the director of professional responsibility of your state and ask them to move it forward and have a formal hearing. I don't know that they're going to do so, but they could. The important thing, though, if you ask me, is for all of the information to go to whoever does the initial investigation. If it's in a state that has a mandatory a bar association, it may be by attorneys. In my state, sometimes the initial investigation is by volunteer attorneys, but if somebody insists that the director of professional responsibility gets involved, then the director would very likely do their own investigation. The director is, in my state, the director of professional responsibility and staff are appointed by the Supreme Court of my state. And that's typically true in every state, except that some states have more involvement by the State Bar Association and some not very much. There typically, in most states, is a professional responsibility board that includes both attorney members and public members. These are not cases that I came up with. These are cases that are in the course that the course author, the person who created the course, came up with. So if you look in the course, you're going to say, hey, those aren't in the module 5 written assignment. True, they're not. But I have a lot of students who are very, very thorough that look at everything in the course, but I also have a bunch of students who are not very thorough, and they don't look at everything in the course, and they are giving me things that aren't right. They're turning in things that don't make sense to me, don't show real research because they don't look at the other content and look at the clues. They will look at this, which is just the written assignment. And obviously this is some use because it's the assignment itself, but does this have all of the information available? No, it does not. It's foolish to only go to the written assignment and then not look at the rest of it. Person should go to the overview and activities, the reading questions, and then of course everything that's here. And so you say, well, so there's cases and there's other items right here. Yes. So you've already got some primary sources here. Schertz case, Tegman case, Patika case. Are you supposed to just use those in the sense of just copying them from here? No, of course not. Look them up and analyze them yourself, build skills. If you build skills, you have gotten value from the course that is long-term. If you just try to memorize a bunch of stuff, true, some long-term memories may be created, but you don't have much value from the course. And here's where it really talks about the difference between ethical violations and malpractice. So And it's kind of subtle because violation of a rule could be evidence of breach of a standard of conduct. So it could help with a malpractice case, but it's not necessarily a malpractice case. Um, and yes, the Tegman case and the Patika case do talk about individuals who are not attorneys could be liable for malpractice if they hold themselves out as attorney or they practice as an attorney. The duty to report is right in here too. Duty to report to the proper authority. And then it gives you these codes, but it doesn't give you links, so you'd have to look them up. Were you able to see what I was showing? Okay. Yeah, it's very important for your classmates that are listening by recording to really focus in and say, I am not going to just give any old answer from any open website. I'm going to use the things in there and then try to find even more in Lexis. It's not just that you gain points, but you gain points for good reason, for gaining skills in research and in gaining skills in analyzing things on your own, using your own words for things. Some of my students are shy about using their own words. I understand that to a point, but that's what's necessary to build skills. If you use somebody else's words, you don't build skills. I would rather have a bad paragraph that is not wonderful, that is totally yours, other than your one reference. You have a reference that kind of got you started with a site, but the rest of the paragraph is not that well written. But if it's you, it earns points for good reason because you are able and willing to work as a beginner, overcome your shyness about that if that's you, and put your own thoughts out there onto the page. That is so major. Um, you know, think of it as um, a class where you're supposed to do research and writing. If you don't do research and you don't do writing, um, you really haven't learned skills. Um, yeah, but I would say we don't have Westlaw, we have Lexis, Heather. It's basically this, it's the same thing with a different brand name. When you get to something in one of these major outfits that are legal research systems, when you get to something on there, some black letter law, which is the actual law, you can scroll down and very frequently you can see the cross references right there, so you know how to interpret it. That's not always true because some rules and statutes are so clear that nobody really needs to worry about them. They're obvious. They don't need to be explained. But many of them, they're explained or used or applied in cases, and you can get right to the cases by just scrolling down on your page. Um, okay, can a paralegal lose their certification if they do not report an ethical violation or is discovered later? That is possible. I don't know if it's happened. Um, where it was, I think, and we'll talk about the whole pattern of conduct. Um, basically, a person could lose their career though if they work for, more likely, lawyers won't hire them if they work for a law firm and engage in a series of cover-ups of the lawyer's bad work. I think it would be better to, in some instances, would be better to try to get out of the situation and let the authorities know that this lawyer is impaired. Okay? Does that make sense, Heather and Zaria? I sort of introduced the idea. Quite a few lawyers are impaired. Um, it may be a small percentage in terms of the total lawyers, but it's not tiny. I mean, I personally knew in a small legal area where there are not that many lawyers, where in this, let's say, 4 county area, 4 not very populous counties. I knew years ago. I knew most of the lawyers, and 2 of them were definitely impaired. One sought treatment and actually did, was able to recover. And the lawyers that worked with that lawyer, instead of covering up, I think they took care of things, and the lawyer sought treatment. That's my understanding anyway. I don't have insight or information. I just know that they did not allow that lawyer to screw up things. Okay. The other one, the lawyer was on his own in a different county, and I was puzzled. I didn't understand what was going on, but the lawyer kept delaying a case, and I thought it was a tactic, but it turns out I learned that the lawyer was impaired, and that's why the lawyer kept delaying. I never saw the lawyer in an impaired condition. Uh, Supposedly, the lawyer indulged in alcohol very frequently. Um, wasn't able to get things done. But I didn't know that at the time. But other lawyers in that lawyer's town apparently didn't do anything about it. That lawyer probably should have been suspended for quite a while until treatment took place. You don't want to be in a situation, if people are turning a blind eye, um, that's really bad. The second thing would be there's a bad kind of a support. Um, there could be negative supporting. That's the second worst. And the best, obviously, is to make sure the person suspends work until after treatment. And of course, somewhere in the middle, um, maybe the person needs to be forced to suspend work on legal matters until treatment. But um, what is it called when they sort of indulge somebody and sort of cover up for them, uh, but it doesn't cause immediate harm? What's that called? Anyway, that happens too. Look at signs of lawyer impairment. Unexplained absences, fails to keep appointments, appears. Um, See, some of these things could lose cases. And this is probably both ethical and malpractice. Okay. Timely, believe it or not, one of the most frequent causes or calls for both lawyer discipline and malpractice is just that there's no communication. Paralegals can certainly help with communication, but if the paralegal has to do it all of the time and keep making excuses for somebody, then something needs to be done. Yeah, Heather says, I will not be able to give you a complete answer to that because it matters. Um, it matters which state you're in. I believe that my understanding is lately my state requires people to report whether they have it or not. So it is on their licensing information that you could look up. You could find out if you looked me up in my state, you'd find out that I do not actively practice law. I'm inactive, even though I'm still licensed. I would have to pay extra, and that I do not have insurance. So if I decided to become active, I would have to pay, I think, what, $45 or $50 for the next year, and then I would have to, from my point of view, I would have to buy insurance. I couldn't understand somebody wanting to do without insurance. But if they don't have insurance, certainly, well, whether they have it or not, it will could result in a personal judgment against them, a court civil judgment, yes. So if somebody missed a deadline and is billed for is sued for $100,000, if they have insurance, they may only have to pay $10,000 out of their pocket, and $90,000 may be paid by the insurance. Does that help? If they don't have insurance, they may have to pay $100,000. Uh, and if they fail to pay it, then they could have property seized by process of law using an execution through the sheriff or so on. They may lose personal goods, bank accounts, uh, real estate um, to sheriff's sale. Okay. So I cannot see lawyers wanting to live without malpractice insurance. Okay. Um, and that's where typically that's why I say try to save your boss $10,000 whenever you can. And you say, well, how can I save my boss 10,000? Well, help the lawyer meet all deadlines. Um, Now, this lawyer, that if the lawyer does a lot of these, you probably can't directly help that lawyer. But the lawyer who very occasionally or almost never misses a deadline, if you help them meet one deadline that they were otherwise going to miss, you may have saved them $10,000. It's very, very important. You can save them $10,000, plus you can save them a nasty note from the attorney's, uh, the Director of Professional Responsibility. Lawyers do not like to get letters from the Director of Professional Responsibility saying a complaint has been made and they are required by law to respond within so many days to that complaint. And of course, then face possible suspension or worse. Disbarment means that they're not even a lawyer. Well, it's much stricter than the question about the Better Business Bureau. It's much more strict than the Better Business Bureau because basically a lawyer is out of business if the Director of Professional Responsibility says they're out of business, they're out of business. The lawyer can bring it to the Supreme Court of their state. The Supreme Court is normally going to agree with the Director of Professional Responsibility. But there are lawyers who will assist lawyers who are charged with ethical violations. And there are certainly lawyers, especially those lawyers that are sued that also have malpractice insurance. There are lawyers who will help somebody who is accused of malpractice. And here's other bad patterns. I never saw a lawyer or judge show up drunk. Um, there was one judge who was hungover, but I was so naive as a young lawyer. I must have been, I did not have the as much, what do they call, streetwise ideas as some folks. Um, I didn't really realize that one of the judges was hungover, but if somebody had said they're hungover, I would not have known what that meant. I mean, I lived a sheltered existence as a young boy. So as a young lawyer, and I was fairly young when I started as a lawyer. Um, I didn't realize that, but that lawyer lost, that judge lost the election then, and so I didn't really face that judge very often. Actually, wasn't a terrible lawyer, very clever person, had been a successful personal injury attorney, but apparently would show up hungover, which basically is not drunk. Hungover just means that they don't feel very good. It's sort of like they have a bad, sick headache. I don't know if you've had to deal with people in this situation, but um, there's all of these things that can go wrong. Um, and if these things are going wrong, it's very difficult for somebody in this situation, if they have two or more of these, or even one, uh, it's very difficult for them to be a good lawyer or paralegal. If somebody is in chaos with their own personal patterns, it's very difficult to do any legal work very well. Malpractice requires both that they didn't use the skill and knowledge required, and they caused actual and ascertainable damages. Basically, this you'll deal with in tort class, proximate cause, but basically it just means that it's fair to say that this lawyer caused money damages, okay? Proximate cause is just a fancy way of basically saying that it's fair to say this person did the damages, that there was nobody else that really caused the damages. Um, it was not a remote cause. But an ethical violation is that they didn't follow the ethical rules, um, and a person can have an ethical violation um, even if there is no damage. And of course, frequently there is damage of some sort too, at least temporary damage. Um, Unethical violation could be malpractice, but not always. I think we've done that, talked about that. Um, the negligence of a paralegal shows a deficiency in the supervision by the lawyer. That's in the Tegman case. And then the Patika case that you have in your materials in the course. Um, it doesn't explain the Patika case, but it just gives you the reference so you can look it up in Lexis or in Fastcase. But when a non-lawyer um, holds himself out as an attorney, courts have held the individual could be liable for malpractice. That's the $100,000 problem, though, rather than the 10,000. If you see where I'm coming from, because you don't have to just pay a deductible; you have to try to pay the whole damages. Deductible is similar to a deductible that you'd have on house insurance or on car insurance, but obviously I shouldn't say obviously, but frequently you have a very high deductible as an attorney, maybe even more than $10,000. Um, Insurance is costly enough that people are not going to buy, well, nobody would really sell a $1,000 deductible attorney's policy anymore. Um, we used to buy $5,000 deductible back when rates were lower. And when I started, you could even have some lower deductibles, but I didn't see the point of having such a supremely low deductible. I didn't like to pay a lot for the insurance. Um, and I can give you some tips about that will help you help lawyers too, as far as insurance. But one of the major thing about reporting both to the insurance company and to the client is just to be extremely honest and thorough and open. If somebody says they're going to make a claim against a lawyer, help the lawyer give the insurance company full information. And you say, well, shouldn't we hide the information from the insurance company because they'll, uh, you know, no, you shouldn't. Better off to tell the whole story because the insurance company and their lawyers can frequently find ways to make sure that the whole case is resolved very cheaply or at no cost. Yeah, you could be pulled into an insurance investigation as a paralegal, and that was asked in the chat. But basically, it's just having the file materials organized so they make sense. That's the biggest thing. Um, when a person uh, when a person tries to make an unjustified claim against a lawyer, um, the first thing we do is organize the file as well as we can so that we can give the correct information to the insurance company. And a lot of times the insurance company and their people can tell us how to squash the unjustified complaint. Okay. And they can help us cut to the chase. A non-client, a former non-client, somebody who was on the other side of the case, tried to bring a claim against me, and I called up my insurance company, and I told the insurance company exactly what was going on, and the insurance company was able to figure it out right away. Now, had I procrastinated, I would have been in agony about it and thinking, well, is there something I didn't understand? This person was never a client. I was on the other side of the case. How can this person be trying to claim against me? And it was kind of an odd situation. Well, um, the insurance company cut to the chase, figured out how to respond, and uh, it was over very rapidly. Uh, I was very open with my insurance company, and I had the lowest rates in the state, they told me. And I talked to another insurance company because I always bid more than one insurance company. I always had them bid against each other. I would turn in at least 2 applications every year, and they told me the insurance agents or sometimes they're called insurance brokers, but they tell me I had the lowest rates in the state. But it was because they knew exactly what was going on about practice and procedures, and you know, they knew the facts. And the more transparent I was about how we did business, the lower my rates got. And but other lawyers apparently um, were vague on apps, or they did them in a rush way. They didn't do them thoroughly, and they had higher rates because the insurance company obviously didn't trust them as much. Having a paralegal lowered my rates. That makes sense too, I would think, to both of you. Um, that's something that lawyers don't know too. Um, having a competent paralegal, um, having a set procedure for how you calendar cases, whether you use sophisticated electronic means to calendar cases, especially like civil cases that have several deadlines, or whether you use a paper calendar or whatever. Having more than one competent person going over the calendar helps. Being willing to tell them exactly what you do, and so on. Um, you don't you don't get automatic discounts for not having claims. Um, what they don't what they're worried about is the big claim that you didn't tell them about, Heather. So the it's claims made policy, so it's um, when they take on a new attorney as a insured, they have to pay um, claims for old actions if there are any claims, because their insurance is based on when the claim was made. So if the claim was not made until they became the insurance company, they have to pay. The old insurance company, when the action was done or when the attorney action was done, does not have to pay. So yeah, there is a statute of limitations, but it's not always helpful because some of the statutes of limitation are discovery rules. So let's say that I read a title on real estate 12 years ago or something like that. And but the defect in title, there was a defect in the title that I didn't discover. Well, the defect or the mistake I made was not discovered till this year. It's possible that the statute of limitations, the 6-year statute, has run and that I'm safe or whatever. And it's also possible that it's a discovery rule and that it hasn't run. So it's really kind of a mess. Note that you don't have to report any mistake. Fraud, deceit, dishonesty, or misrepresentation. Negligence does not need to be reported under the ethical code, but I still think you should help deal with it in some way. Try to get the attorney to get an attorney in the same field of law to assist on these difficult cases where it looks like negligence is happening. And obviously, you may not have that much influence over the attorney, but if you have no influence, then maybe you should quit if there's negligence. Quit that attorney. Work for somebody else. Here's my last little speech here about this. I do not want paralegals who work for attorneys to take on the stress that attorneys are paid to take on, okay? I don't want you to be, I don't want you to neglect things or to be, or to be a procrastinator or anything like that. But so be thorough, but don't take on the worry. Comments, questions about that? There are problems with legal work. There are problems with legal work that do not have to result in blame for the paralegals. The lawyer is the one that decides to take cases, and if the lawyer decides to take on 60 cases, that's not the paralegal's fault. The paralegal can quietly encourage the attorney to have an organization day. And I know a lot of paralegals do not maybe have the family flexibility to do this, but coming in on a Saturday morning for a couple hours and when nobody thinks you're open sometimes helps. And just organize the files and find out which files should be closed and which files need immediate action and which files need further calendaring, things like that. Which files are progressing fine, but you haven't communicated with the client. That's another major one. If you talk to any malpractice carrier, they're going to say, well, what's your policy on communicating with clients? Because they don't want to take on attorneys who ignore the clients for months at a time just because the case has to wait. Do you see where I'm coming from? you have to be proactive in communicating with clients, not wait for the client to bother and buzz and say, "Oh, I'm sorry to be a bother, but I haven't heard from you for 2 months." You don't want to be that kind of a law firm. You want to be the kind of a law firm where the client receives messages even if nothing has happened. Um, as we stated earlier, the the judge and the court system is not willing to do any more for the next 2 months. It'll just have to wait. There's been a delay, and we did all we could to get it done, but we'll all have to wait. That kind of a letter might have to go out a couple of times. It's embarrassing to write that. You don't want to do it. The lawyer doesn't want to do it, but do it. And obviously, again, get the lawyer's signature. Don't send it out on your own signature. Another one would be clients will wait and wait, and sometimes some clients will do nothing. You told them to bring in more information, they didn't do it, and then they blame you and the lawyer. You should send out a follow-up letter um, and remind them, we are still wanting to work on your case, but we need the information from you. And you're supposed to either bring these in paper form, or you need to scan your documents and send them to us that way. But we cannot work further until you give us the information. Okay, so that happens. Too much to do is not your fault. Most lawyers have not taken a course in management and supervision. Most have not been managers before being busy lawyers. What I'd like you to consider, and this is true for most paralegal fields, organize, communicate, and go home on time. If you can't do that, I sure hope you're being paid a lot, because you're not an attorney, you're not paid as an attorney. And if you cannot organize, communicate, and go home on time, I'm not sure you should be working there. Save, help, organize, write. Create a file on mistakes and omissions. Check files for steps missed based on previous similar files. This will also help when your attorney that you work for applies for insurance, because they will be very impressed by the fact that your law firm is fixing everything. Get help from others if at all possible. Organize, do calendaring, create reminders and notes. Communicate this in writing to the attorney or to others if needed. Go home on time. So if you've saved, helped, and organized and written, then I want you to go home on time. Don't solve all the troubles. If there's a troubled law firm, it's not your problem to solve them. Just document the problems and get it onto the desk of somebody who is supposed to solve it. Somebody who has signature power in the law firm. Okay. Attorneys do not have work-life balance, or at least very few of them do. But they took it on. They have the signature power. They can decide, they can tell you, I'm not taking any more cases for the next 40 days or until we get down to 35 cases. They can do that. It takes some guts, but they may need to do that. Or if they are doing only major cases, maybe they can only take on one case in the next month if they're doing these major cases. It depends on the type of law and the type of cases, type of clients, and so on. There's no one final answer on this, but you have to use your best judgment. But I would like you to consider this as a way of working. If like many law firms, it's a very stressful place to work, it should not be that stressful for paralegals and other assistants. Save, help, organize, write, SHOW. What does the acronym SHOW stand for? I'm putting you on the spot. I know there's only two of you, but take a shot at it. A, B, C, or D? Close. I don't want, once you've done that, I don't want you to work anymore. Save, help, organize, write. So save the information, get help, organize things, and then write your memo, slap it on somebody else's desk, and then leave. Now, if you're doing remote work, you basically do the same thing electronically. You save the information electronically, put it in the right firm folder for the law firm, get help from somebody else in the law firm as you can, organize the information, and then write your memo saying, I just don't think this is right. It looks like we should have done this on Monday, and here it is Friday. The client is expecting a report on everything we did, and we basically didn't do anything, and write it down and suggest that the attorney or a different attorney get involved right away the next Monday. Okay. In the case, in this week's story, it is a total mess. Friendship ethics was used when strict legal ethics was necessary. Bad habits of practice build up, as do good ones. Um, there's certainly a risk defying orders of the supervising attorney, but that is needed. The actual rules established in your state that are enforceable at the time of the problems count most. Um, if you have been studying the ethical rules and looking at the case decisions below those in Lexis, you will see the scope and depth of the trouble. A lot of hints are also in the lesson, such about when a paralegal should report, which will not be covered in primary sources like state rules. So um, when a paralegal should report will not be in the law. It'll be in your paralegal association things that are covered in the um, lessons. If you're doing excellent work and spending too many hours second guessing yourself and going in circles, stop. Set a timer. When it goes off, in other words, set a timer, do the work, and when it goes off, spend 5 minutes proofreading and turn it in. It's actually faster to do 2 alternative answers than to go in circles mentally. I used to say, when in doubt, type more. Other teachers, and this is the Kirk Olson stuff here. Um, is right there. Um, now, other teachers that you have will say Kirk is wrong about when in doubt, type more. We don't want reams and reams of typing in a law office. I understand why they say that as practitioners and so on. I understand that, but in my class, I'd rather have you type more. Uh, in some law firms, not mine, but in some law firms, you have to boil it down to something very short. I'd rather have the long information and I will skim through it. Other lawyers want you to boil it down, but I think you should still have the long version because the lawyer that wants to find something that should be 5 pages in only 1 to 2 pages um, is going to ask you questions. So you should have the other 3 pages be your notes. Does that make sense? Do you see where I'm coming from on that? Don't go in circles, type more. Just get it down on the page. And like I say, in some law firms, you'll have to keep a bunch of it for just your own personal notes, and the lawyer won't want to read it unless they have questions. But then at least you can answer them under pressure because you've written it down in your own notes. If you work for me, I'd rather have the whole business in one document. Okay. And as you take a class from me, go ahead and put the extra stuff, the second guessing, go ahead and put that below your main answer. And if your second guess is actually right, you're still earning points. Does that make sense? Do you see why I still give points for that, even though you don't have it where I thought you should? Yeah. it never confused me when a employee came up with two answers that are contradictory. It never confused me. I don't see why it confuses other people. Just giving me two options does not bother me. That's one of the things I did for clients is I gave them more than one idea. I said, you can go this way or that way, you know. I said, well, um, for instance, in practical terms, a person would come in and say, I want to help my nephew and niece, um, and they're in financial trouble. And I would not necessarily give them one possible way of doing it. When they explained the whole situation, having to do with mortgages and businesses and all of this other stuff, I normally would give them at least two options, not one. I don't understand the one option thing, but other lawyers like the one option thing. You give them one answer, and you organize it. That's fine. I'd rather have you, if you're going in circles, otherwise, I'd rather have you give me both answers. Get it down. Expansion and cutting down to size help. I want you to learn to do both. Learn both skills. Don't claim confusion or object to the assignment either here or at work. Just say, here's what I came up with. Um, this is the part I did not understand. This is what I think about that so far, but I didn't thoroughly understand it. And just explain yourself. Here's how far I got. Here's where I got stuck. I hope you get really difficult assignments where you end up um, contacting somebody like the Lexus reference attorney. You say, well, can I use Lexus, boss? Yes, you can use Lexus. Well, I contacted the Lexus reference attorney and they didn't even know what it was, what we were trying to deal with. They found some materials and here they are. Um, and then I called the state law librarian in our state and they couldn't come up with any more than this. And here's this, and here's what I came up with. Giving them the raw information that you have not totally sorted out is a lot better than just saying, I couldn't solve it, so I didn't do anything. If you just give them nothing, you say, I did not thoroughly understand everything, so I give you nothing, then you won't be assigned high-level tasks. Lawyers lawyers won't do that then, and that's terrible. With all this education, not to get the high-level tasks, that's a bad thing. What you want to do is just explain which parts you were able to solve and understand and which parts you had difficulty with. Sometimes the parts you have difficulty with um, are the same things that the judges and lawyers have difficulty with. So, surprise, surprise. I mean, that's why legal work is hard. It's not super easy because there is not a ready-made answer to every situation. So, uh, this this is the one that I don't really teach. I do think it's needed, but I don't actually teach it. The other teachers do a good job with editing down the content to only the essentials. I do these too. So first you learn to expand my way, and then please learn how to edit it down. But my suggestion is when you learn to edit it down, keep the other part as your notes. Okay. And if you work for somebody like me, it's all one document again. It just depends. And I'm not asking this as this is a rhetorical question, so I don't want you to answer this in case you do work for an attorney. But if this is true, if drinking heavily and gambling are the main recreation, then you have to ask yourself, are cases being neglected? There's danger in anybody. I haven't seen this with necessarily with attorneys, but even people who have worked for cities and many other like counties and so on have been caught using city money for gambling. Well, it's possible an attorney could dip into trust account money or something and end up in jail if they do this, if they use it for gambling. If you see attorney problems, don't ignore the problem. Do not take it with you and turn it over in your mind until you have a complete solution. I want you to SHOW, save, get help, organize, and leave it. Go home. Save, help, organize, and write, okay? Write a memo, leave it on somebody else's desk. You go home. When you're asked to review a professional responsibility issue, you should ignore both methods and knowledge. No, I don't want you to do that. Surprisingly enough, I don't want you to just see what you recall from my answers. Even if my answers are basically correct, I want you to update it and find the newest citations, the newest laws. Use thoroughness and critical thinking. And SHOW stands for Save, Help, Organize, Write. And consider which, and this will basically, as you look on those items as far as when you tell an outside authority and how you deal with it in the law office, of course, will help with the written assignment. And here's the live classroom quiz answer is show and tell. And I realize we're going a little bit long here, but just a couple more slides, which are kind of repeats of concepts, but I'm going to run through them, show and tell. Do you need to do more or do you need to learn to stop? Some of you need to do more. Some of you listening by recording need to do more because you are not being thorough. You're spending a few minutes on something that should take hours, and you're wasting your money taking the course if you just dump something into the message box and into your document and don't do much work on it, then you're wasting your time. If you are going and spending way too many hours, losing sleep, you're spending too many hours second guessing yourself, then I want you to set a timer for yourself. Critical thinking at Rasmussen College, what is it? It's not a fair way to explain someone's faults, not that kind of criticism. It's not to review my thinking or other instructors' thinking, it's your own individual thinking. Critically important individual thinking. And that's it, I think. Let me see, do I have one more slide? Nope, that's it. Thanks for working with me. Yes, it's this. Show and tell. Those are the two words. Okay? That's what gets the attendance points.